This is the moment we've been waiting for. Patriots, after years of watching our rights trampled by activist courts, the Supreme Court just loaded 5 massive Second Amendment cases onto their conference docket. Every single case has the power to destroy decades of unconstitutional gun control. If you want to see freedom win, hit that subscribe button right now, because what happens next will change everything. The Supreme Court's silent strategy. The Supreme Court's silent strategy. The justices didn't just randomly pick these 5 cases out of thin air. What most people miss is that the court has been deliberately waiting, watching lower courts twist themselves into knots, trying to avoid the Bruen standard for the past 2 years. Right now, there are 17 different federal circuit courts applying 17 different interpretations of the same Supreme Court ruling. The Ninth Circuit claims magazines aren't arms. The Seventh Circuit says AR-15s aren't protected because they're too common. The Third Circuit invented a new historical test that would have shocked the founders. This isn't confusion anymore. This is outright judicial rebellion, and the numbers prove it. The Supreme Court knows exactly what's happening. They've been collecting these cases like ammunition, waiting for the right moment to fire back. 5 cases appearing on the same conference docket isn't standard procedure. The average number of gun rights cases the court considers per term, 1.35 cases at once, signals something massive. The justices are preparing to issue what legal scholars call a clarifying barrage. Multiple rulings released close together that eliminate any wiggle room for lower courts. But before the court can rule on anything, they have to actually take these cases. And what happens in that conference room will determine whether we're headed for the biggest Second Amendment victory in a century or watching our rights circle the drain for another decade. Inside the conference. What actually happens? Conference, what actually happens? Most Americans have no idea how Supreme Court conferences actually work, and that ignorance is exactly what anti-gun groups count on. Here's what goes down behind those closed doors. 9 justices sit around a table in order of seniority. No clerks, no staff, no recordings. Just 9 people who will decide the fate of your constitutional rights. The Chief Justice speaks first about each case. Then each Associate Justice speaks in descending order of seniority. Nobody interrupts. Nobody debates during the initial go-round. After everyone speaks, they vote. 4 votes grants certiorari 4 out of 9. Here's where it gets interesting. Right now, we've got 6 justices appointed by Republican presidents and 3 by Democrats. Simple math says, gun rights win easily. Right, wrong. The reality is more complicated and more frustrating. Chief Justice Roberts has a documented history of trying to avoid controversial 5-4 splits. He'd rather issue narrow rulings that technically favor gun rights, but leave enough ambiguity that anti-gun states can keep restricting. Justice Barrett wrote the Bruen decision's concurrence specifically highlighting concerns about sensitive places restrictions. Justice Kavanaugh has signaled openness to certain categories of gun control. The conference will reveal which justices are willing to finally draw a hard line. If they grant cert on multiple cases, it means at least 4 justices are done playing games with lower court defiance. If they only take 1 case or none at all, it signals the court wants to avoid the political firestorm that comprehensive Second Amendment protection would create. Assuming the court does take these cases, the first one they need to address is the fight that's been raging in California for over a decade. And it's not just about magazines anymore. The California magazine ban. Why this case breaks everything. The California magazine ban. Why this case breaks everything. Duncan versus Bont represents the single most important property rights case in American history that nobody's calling a property rights case. California banned magazines holding more than 10 rounds in 2016. Standard capacity for most modern handguns is 15 to 17 rounds. For rifles, 30. That means California criminalized items that roughly 114 million Americans legally own. The state initially said current owners could keep their magazines but couldn't buy new ones. Then, in 2019, a district judge issued a stay, creating what gun owners call Freedom Week. For 6 days, California residents could legally buy standard magazines. Here's the part that should terrify every American, regardless of how you feel about guns. California is now arguing that those 2 to 3 million magazines purchased during a court-ordered legal window must be surrendered, destroyed, or permanently modified. No compensation, no grandfathering, just compliance or felony prosecution. The state claims it can retroactively criminalize property that was explicitly legal when purchased. Think about that framework applied to anything else. Imagine buying a car that meets all emission standards. Then 5 years later, the state decides that model is now illegal and you have to destroy it or face prison. The Ninth Circuit endorsed this theory. They ruled that magazines are not arms under the Second Amendment. Therefore, the government can ban them without constitutional scrutiny. That same logic applies to any firearm component, triggers, barrels, stocks, even ammunition itself could be banned overnight if magazines aren't protected. 12 states are watching this case specifically to see if they can implement similar bans. California's magazine ban at least pretends to be about capacity limits, but the case coming out of Illinois doesn't even bother with that fig leaf. The assault weapon ban. Illusion, Illinois' categorical prohibition. Weapon ban illusion, Illinois' categorical prohibition. Harold versus Raoul, the challenge to Illinois' assault weapon ban exposes the entire lie behind modern gun control. Illinois didn't ban magazines or accessories. They banned the guns themselves. Specifically, they banned over 190 models by name, plus any semi-automatic rifle that accepts a detachable magazine and has one cosmetic feature from a list. A pistol grip makes it an assault weapon. A folding stock makes it an assault weapon. A threaded barrel makes it an assault weapon. These features don't change how the gun functions. The Seventh Circuit upheld this ban using reasoning that would make George Orwell proud. They argued that AR-15 and similar rifles are essentially the same as military weapons, therefore not protected by the Second Amendment because they're too dangerous. Then, in the same ruling, they argued these guns aren't commonly owned enough to deserve protection. Both arguments can't be true simultaneously. Either these rifles are everywhere, which makes them common and protected under the Haler decision, or they're rare military weapons. The data destroys their argument. Americans own over 24 million AR-15 pattern rifles alone. Illinois' ban doesn't stop with rifles. It includes specific pistol models, shotguns, and even requires registration of currently owned firearms within 300 days. Owners who don't comply face felony charges. The state created a searchable database of every registered assault weapon owner, essentially building a confiscation list. 7 other states passed similar laws in the 18 months after Illinois went first. While California and Illinois attack the guns and magazines themselves, another case on the court's docket targets the people who own them. The prohibited person's trap. How a youthful mistake costs rights forever person's trap. How a youthful mistake costs rights forever. Vincent versus Garland challenges the federal law that strips gun rights from anyone convicted of a crime punishable by more than 1 year in prison, even if they never served a day. That standard catches more people than most Americans realize. A college student who gets caught with marijuana at a music festival, convicted of possession, potential sentence, 3 years, actual sentence probation. Under 922 G1, that 20-year-old kid loses his Second Amendment rights for life. A woman who writes a bad check for $600 during a financial crisis. Felony fraud in her state. Potential sentence 18 months. The Bureau of Alcohol, Tobacco, Firearms and Explosives estimates that 9 million Americans have lost gun rights under this statute. 9 million people who committed non-violent offenses served their time and returned to society as productive citizens. But the Constitution apparently doesn't apply to them anymore. Not just the Second Amendment either. These prohibited persons can't live in a house where someone else owns guns. They can't go to shooting ranges. They can't handle firearms at work, which eliminates entire career fields. The petitioners in Vincent aren't arguing that violent criminals should have guns. They're arguing for an individualized assessment, show that the person's specific offense and history pose a genuine danger or restore their rights. The government opposes this because it would require actual work. Right now, the ATF just runs a background check, sees any felony, and denies. Automatic, efficient, completely divorced from whether that specific person actually threatens public safety. Roughly 2.7 million of those 9 million prohibited persons have never committed a violent crime. The prohibited persons cases reveal how far the government will stretch Gunby, but there's a historical angle that destroys every single argument they're making. The text, history and tradition. Standard. Why the government keeps losing history and tradition standard. Why the government keeps losing. Bruen didn't just change gun law, it changed how constitutional analysis works for the Second Amendment. Before June 2022, courts used means end scrutiny. The government would say they have an important interest in public safety. They'd show their law advances that interest and courts would defer unless the restriction was completely irrational. That standard let basically everything pass. California's magazine ban, Illinois' assault weapon ban, prohibited person statutes, carry restrictions, gun-free zones, waiting periods, purchase limits. Brewing through that entire framework in the garbage. Now, the government must prove their restriction is consistent with America's historical tradition of firearm regulation, not European traditions, not modern traditions. The American tradition from the founding era through Reconstruction. If similar laws didn't exist, then the restriction is unconstitutional. Period. No balancing test, no public safety exception, no times have changed argument. This standard is why lower courts are in chaos and why anti-gun judges keep ruling against gun rights anyway. They can't find historical analogies for modern bans because those analogies don't exist. The founding generation didn't ban any type of weapon. They didn't prohibit carrying in sensitive places except courtrooms and polling places. They didn't have magazine capacity limits because magazines didn't exist yet. Repeating firearms did exist. The founders knew about puckle guns which fired 9 rounds without reloading. The text, history, and tradition standard makes magazine bans, assault weapon bans, and most prohibited person restrictions facially unconstitutional. The government has to prove these laws match something from the founding era. They can't. So, they're inventing historical analogies that never existed, which is exactly what the Supreme Court told them not to do. The historical standard would be enough to strike down most gun control. But there's another legal principle that makes these bans even more indefensible: the common use. The common use doctrine, when popularity becomes protection. Doctrine, when popularity becomes protection. District of Columbia versus Haler established that weapons in common use for lawful purposes cannot be banned. The court specifically said, the Second Amendment protects arms that are typically possessed by law-abiding citizens for lawful purposes. That standard makes modern gun bans legally impossible to defend because the guns and magazines being banned are the most popular in America. Standard capacity magazines aren't exotic or unusual. They're what comes in the box when you buy the gun. Glock 19, most popular handgun in America, ships with 15-round magazines. AR-15 pattern rifles exceed 24 million in civilian ownership. That's one AR-15 for every 14 Americans. More people own AR-15s than own motorcycles, more than own boats. These rifles are used in less than 2% of all gun crimes, according to FBI data, but they account for 60% of rifles sold annually. They're common use to find. The protection isn't about need. It's not about sporting purposes. The Heller decision explicitly rejected interest balancing. The common use doctrine also defeats the dangerous and unusual weapons exception. Anti-gun activists love claiming AR-15s are dangerous and unusual, but both prongs have to be satisfied. Even if you accept that semi-automatic rifles are dangerous, which is debatable given their low crime rate, they're definitely not unusual. 24 million copies of anything is common by definition. The government tried arguing in lower courts that commonality doesn't matter if the weapon is dangerous enough. Every legal argument supports gun rights. Every historical analysis supports gun rights, and the popularity of these firearms supports gun rights. The judicial resistance. The judicial resistance movement. Why lower courts ignore the Supreme Court movement. why lower courts ignore the Supreme Court. Federal judges are deliberately defying Supreme Court precedent, and they're not even hiding it anymore. Judge Roger Bonitez in Southern California struck down California's magazine ban twice. The Ninth Circuit reversed him twice. He followed Bruen's framework exactly, found no historical analogue for magazine bans, and ruled the law unconstitutional. The Ninth Circuit said his analysis was wrong because he didn't consider the government's public safety interests. That's the exact approach Bruen forbade. The Ninth Circuit knows this. They don't care. The Seventh Circuit did the same thing in the Illinois assault weapon case. They admitted AR-15 is in common use. They acknowledged Heller protects commonly used weapons. Then they created a new exception out of thin air, claiming weapons that are too much like military arms lose protection, even if they're common. Where did this exception come from? Not Heller, not Bruen, not any Supreme Court decision. The judges just made it up because they didn't like the result that following precedent would require. This isn't judicial interpretation, it's judicial nullification. Between Bruen's decision in June 2022 and December 2024, federal courts decided 218 Second Amendment cases. Gun rights prevailed in only 59 of them. That's a 27% success rate under a standard supposedly designed to protect gun rights. The pre-B Bruen success rate was 31%. The new standard made things worse. The outro Supreme Court has three options. They can keep remanding cases with instructions to follow Bruen, which hasn't worked. They can let lower court defiance stand, which destroys their authority, or they can grant certiorari on multiple cases simultaneously and issue unmistakably clear rulings that eliminate any interpretive wiggle room. Either the Supreme Court enforces its own precedent now, or we accept that the Second Amendment means whatever 9 judges on the Ninth Circuit say it means. The Supreme Court conference is happening right now. And you need to be ready when those orders drop. Smash that subscribe button and hit notifications, because the moment the justices announce which cases they're taking, you'll hear it here first, with full analysis of what it means for your rights. Share this video with every gun owner you know, because if we lose in the courts, we lose everywhere. Drop a comment telling me which case you think matters most. And remember, patriots, they don't grant us our rights, so they